Hi everyone, I am Bhavna, 5th semester, Electronics and Communication Department of Sri Venkateshwara College of Engineering. Today, let us deal with the subject Research Methodology and Intellectual Property Rights. Prepare a video on types of research and also about the penetable items in brief. That is a topic. Introduction. There are various established methods used in research to investigate a problem or research in question. It plays a vital role for the researchers to prove the hypothesis based on clarity defined parameters, environments, and assumptions. Understanding and having a deep knowledge about the types of research can help the researchers to better plan the project by utilizing the most appropriate methodologies and techniques. Types of research methods and examples. Research methods are broadly classified as qualitative and quantitative. Both methods have distinctive properties and data collection methods. Qualitative methods. Qualitative research is a method that collects data using conventional methods, usually open ended questions. The responses collected are essentially they are non-numerical. This method helps a researcher understand what participants think and why they think in a particular way. Types of qualitative methods includes one-to-one interview, focus groups, ethological studies, text analysis, and case study. These are the qualitative methods. That is the first type. And the next type is quantitative methods. Quantitative methods deal with numbers and measurable forms. It uses a systematic way of investigating events or data. It answers questions to justify responsibilities of relationships with measurable variables to either explain, predict, or control a phenomenon. Types of quantitative methods includes survey research, descriptive research, and correlative research. These are about the quantitative methods and types of it. Introduction to patents and patent searching. A patent is protection granted by a national government for an invention. This protection excludes the others from making, using, or selling an invention for a period of up to 20 years. Many drug companies and university researchers seek patent protection to recover research and development cost for patent related to specific genes and proteins. Laboratory techniques and drugs. In order for patents to be issued by a granting agency such as patent office, they need to be new, useful, and also obvious to others working in the same field. Requirements of patentability, usefulness or utility. The claimed invention must be useful or functional. A machine must work according to its intended purpose, and a chemical must exhibit an activity or have some use. Novelty, the invention must be different than anything known before. It must not been described in a priority publication, and it must not have been publicity used or sold. Non obesity or ingenuity, the invention must be development or an improvement that would not have been obvious beforehand to workers of average skill in the technical involved. Novelty and non obviousness are judged against everything publicity known before the invention as shown in earlier patents and other published material. This body of public knowledge is called as prior art. So here are the four reasons to file a provisional patent. So these are it's an information regarding the provisional patent. There are the four reasons for it, which has been shown in the figure. Types of patents. There are three types of patents. Utility patents issued of any process, machine, article of manufacture, or compositions of matter, or any new useful improvement. In general, this type of patent protects the way an item is used or work. For example, golf club head design patents issued for a new original and ornamental design for an article of manufacture. In general, this type of patent protects the appearance of an item. For example, safely goggles. Plant patents issued for asexual reproduction, distinct and new varieties of plant. For example, a Dihera plant named Mystic Wizard. Patent families. A patent family is a group of patent document for different countries that protect the same invention. Defines the geographic scope of patent protection for an invention. Is useful for locating the alternative language versions of a patent document. Note: patent coverage only appears within the country that grant a patent, so that an inventor must file a patent application in every country for which protection is wasted or wanted. 5 simple tips on how to patent your research. Securing the patent protection is one of the most important way of safeguarding your intellectual assets. In order to succeed and stay on top of the game, companies must distinguish themselves for their competitions based on their intellectual property portfolios. So, patent protection stops your contenders for making, using, distributing, or importing your innovation in the country or countries in which the patent rights are granted. Strike early by prioritizing patent. You must miss out and protecting invaluable intellectual aspects if you do not know what sort of technological advancement can be patented. Consequently, one of the most important steps for acquiring the patent is identifying all the potential technologies earlier in the development process. This helps in preventing unauthorized disclosures. If a technology is discussed in public, its patentability is lost. Know what can be patented. There are three key conditions: novelty, innovation, and industrial applicability, which must be fulfilled for an idea to be patented. The invention must demonstrate a new characteristic that is unknown in the current body of the literature. It should be such an individual with ordinary skills in the relevant field should not be able to deduce it very easily or obviously. Conduct a throughout patent research. Before filing a patent, one should ensure that the innovation has not been anticipated by publication in any form of priority to the data for filing the patent. For confirming this, one must conduct an executive patent research. There are various methods of identifying already existing patents. Conclusion: the objective of the patent is to provide a right to inventor to exclude others from exploring the patent invention. Therefore, other than an inventor cannot use, make, or sell the patent invention without permission from the inventor. This is often referred to as an exclusive right of the invention. So this is about the types of research and patentable items in brief. Thank you. Thank you for the session.